welcome everybody then to this Law and Economics Centre program on civil justice, the Congressional Civil Justice Academy, which is part of a series of programs run by the Law and Economics Centre here at George Mason Antonin Scalia Law School. The purpose of the Law and Economics Centre is to educate all types of people on economics and legal issues, and part of that is this series of programs, the Congressional Civil Justice Academy, which before COVID happened in person on Capitol Hill, but since COVID is sort of translated into this webinar series. And today's webinar is about the growth of multi-district litigation, MDLs, what is driving that, and what consequences that has for civil justice. So before we get on to that, I have to plug the next session that we have, which is Tribal Law 101. That will be on Friday, November the 12th. And it's a little, it's going to be a session run by Adam Crapel, who is my colleague and professor of Indian law here at Scalia. And he will be taking us through federal impediments to Indian tribes and what can be done to drive economic prosperity on Indian reservations. So we're looking forward to that, and hopefully you can all attend that as well. So straight on to today's main event, which is about the growth of multi-district litigation. We've got a great panel for you today, starting with Ben Halperin, who is an associate at Skadden Arps and deals mainly with multi-district litigation. I'm going to introduce each speaker just before they speak, only briefly to give them a chance to talk about their experience in the field, and then we'll have a quick panel discussion, and then questions and answers. And if you have any questions, put them in the chat, and I'll feed them into the panelists to make sure that they can be answered properly. So to open us up, could I ask Ben to tell us his experience of MDLs?
Thanks so much, Matthew. Thanks very much to the Law and Economics Center for having me. I just introduce myself again. I'm Ben Halperin. I'm an associate at Skadden Arps, where I practice product liability and consumer litigation, a lot of which involves MDL proceedings. So the first thing I wanted to do is just talk about the numbers of cases that are in these MDL proceedings. And I've done some research into this using publicly available information. You can get data on the number of pending cases in MDL proceedings from that's published by the Judicial Panel on Multi-District Litigation. And there are also publicly available data on the total number of pending civil cases provided by the US courts. So I recently looked into this and just tried to compare what percentage of the cases in the federal civil cases are MDL cases. And I looked at data from this summer. So there were data from July 15th on the pending cases in the MDLs, and federal court data from June 30th. So 2 weeks apart, pretty much as apples to apples as you can get. And one thing I noticed when delving into this is that new numbers are coming out all the time. So you kind of have to pick a place to stop and sort of get off the merry-go-round. Otherwise, you're just going to be constantly updating. And so let me just give you the numbers of what I found. So what I did was I looked at the total pending cases as published in MDL proceedings, and didn't just look at all MDL proceedings, tried to identify the ones that are primarily focused on personal injury litigation, and identified about 50 proceedings that are primarily designed to address personal injury claims by looking at the transfer orders to verify that the allegations mostly involved personal injury, weeding out antitrust, patent cases, things like that. And as of this summer, what I found were there were about 368,000 pending cases in MDLs that are about personal injury claims. And that compares with 605,000 total civil cases in the federal courts. And then the federal court data, actually, they report on private versus public cases. So in public cases involve the federal government, and For some reason, a lot of those cases, they have unique procedures because they're Social Security claims cases or prisoners cases. A lot of them are those. So if you take out the public cases, it was 553,000 total civil cases. So the math on that, just based on the numbers I used, and I'm happy to share specifics about which MDLs I considered, and you can use the publicly available data. If you look today, I think there's 406,000 cases in all MDLs according to the data from last week. So I concluded that 60% of the total federal civil total are pending cases in personal injury based MDLs, and pretty much 2/3 on the nose, 66.5% if you get rid of the public cases involving the federal government. And about a few years ago, around 2017, a lot of people were writing that the number was about 1/3. And I know some of the other panelists here put out that number. It seemed pretty uncontroversial a few years ago. So I calculated roughly twice the increase. Admittedly, a lot of that comes from a few particularly large proceedings. For example, there's the large proceeding in Florida involving combat earplugs, which has a couple 100,000 cases in it. But those are the numbers today. That proceeding exists. The numbers can change over time, but who knows that there won't be more similarly large proceedings soon. So it's fair to ask, what do these numbers mean? Is it really a problem? I mean, on the one hand, large scale personal injury litigation in MDL proceedings, they involve product liability. It could be products that are mass marketed. They might have allegedly injured a lot of people. It's called mass torts for a reason. This is the mass part of it. So it's not surprising that there are a lot of cases. And at least, in America, one could plausibly argue that, if someone sells something or does something that injures thousands of people, it's only fair that they confront thousands of lawsuits. Well, I think there are some reasons why this is quite problematic for litigants. And just to briefly put this in perspective, I'd like to analogize it to going to the casino and playing blackjack, which I think is the second most fun game you can play there after craps. Normally in blackjack, you sit at the table and maybe you have a friendly dealer. Normally maybe you have an ice cold dealer, but you're probably not going to win tons of money in one sitting. And there are some reasons for that. One is that the dealer has a card hidden that's eventually shown, but the players don't. They have to show all their cards. And the other is you have to post a meaningful ante in order to win something. Maybe it's you post $10 in order to win $10 or $20 if you double down, but it's not like you're putting down, say, $40 to win potentially hundreds of millions. So imagine that it were flipped, however, and that you could ante $40 to potentially win 100 million on a hand, and you didn't have to show your cards at all. You could just keep them hidden. How would casinos stay in business with that? They would. I mean, I don't know how they're doing in the pandemic anyway, but there would probably be some doubts about that. It's an imperfect analogy. I'm sure that I will be downbirded on it by my fellow panelists, but it does describe what this looks like from a defendant's perspective, because the truth of the matter is that when you're litigating these large proceedings, there's not a mechanism in place to learn basic essential information about what the vast majority of cases on the other side look like. You can't move to dismiss individual cases on individual grounds. You don't get case-specific discovery. You can't move for a more definitive statement. In that respect, it's at least somewhat ironic that you have so many cases, call it a large plurality or a majority, and many of the federal rules of civil procedure just aren't available. They don't apply even-handedly to both plaintiffs and defendants in this case. And as a result, if you're a defendant, trying to figure out how to strategize, trying to figure out what your exposure is, you don't know really essential information. If you sell a product, you don't know what percentage of the claimants really used it. You don't know, how many are injured and what the varying extent of the injuries are. And you don't know, are there a bunch of claims in there that are long past the statute of limitations? All of that, I'd argue, is quite essential information that nobody would dispute should be available to defendants in individual litigation. But in this context, which are just a ton of cases, you don't have it. And it also ultimately these will settle. But when defendants are trying to figure out how to settle, you don't know if you're overplaying. If a plaintiff's firm has a large inventory of 3,000 cases or so, you don't really know what's behind the curtain there. It just presents challenges, and I would also suggest that it can be bad for plaintiffs too. If you are a particularly deserving claimant who's seriously injured, you need to recover, it can take a long time to recover. You don't have any control over how, your case is being prosecuted in this inventory unless you're, kind of win the lottery and get to be a bellwether case. And it's a possibility that in a settlement, your recovery could be diluted by weaker claims. And I'll admit, as a defense attorney, I don't really know how the settlements get paid out. Once they get paid to the plaintiff's attorneys, it's a black box and they're confidential. But that's part of the problem. And with that, I'm going to do something great in all business and identify a number of problems and leave it for discussion on the solutions. So thank you very much.
Thanks, Ben. That was a good start to get the ball rolling. We also should note that the 3M MDL is the one that is potentially the largest MDL, has 272,381 cases within it, and that potentially skews the numbers, of course, but definitely figures in what you're saying. So next up, we have Alex Dahl. Alex has had nearly 3 decades of experience in law and advocacy. He is currently the General Counsel of Lawyers for Civil Justice, and Lawyers for Civil Justice supports amending the federal rules of civil procedure to provide more guidance on MDLs, and he has made specific proposals in relation to that, as has LCJ, the Lawyers for Civil Justice, and I'm sure that he'll be happy to talk to us about those proposals and what he thinks will be the best outcome in that process. So, Alex.
Thank you, Matthew. And I really appreciate the comments that Ben made highlighting the numbers. It is obvious, I think, to anyone looking at the numbers that nobody foresaw in 1968, when the MDL statute was passed, what this would mean in the future, and that we would be in a situation with hundreds of thousands of cases and a clear majority of the civil docket consolidated into MDLs. It's one additional statistic I would like to add is that there is tremendous consolidation in this as well. There are only 16 MDLs with over 1,000 plaintiffs, but those 16 cases make up over 96% of all the MDL cases. So we're really talking, at least in my mind, about the cases that are over 1,000 plaintiffs, and that's where the real problems occur. Now, just as nobody foresaw in 1968 what MDLs would become today, even more so, nobody foresaw in 1938, which is when the federal rules of civil procedure first went into effect, that there would be cases with thousands of plaintiffs or tens of thousands or hundreds of thousands. Our civil rules are not designed for this. But what we have now, because of that, is that a huge percentage of our civil docket exists essentially outside of the federal rules of civil procedures. And that is because in these big cases, judges and parties are making up ad hoc procedures to substitute for the FRCP that aren't providing the pragmatic guidance that they do in all other types of cases. It is important to realize that when the 1938 effort was underway, prior to 1938, that one of the real focuses was on protecting the judiciary and defendants from meritless claims. And if you look at the rules of civil procedure, you will see that a number of the rules pertain exactly to that. I will point to 7, 8, 9, 10, 11, 12, and 56. These are all rules that govern what pleadings are and how they must be sufficient. They are rules that are designed to make it easy for the courts to make sure that their dockets are not clogged with claims that have no merit and don't deserve to be in court. Starting, by the way, with Rule 3 that says that an action is commenced with a complaint. And as a side note for now, these shadow dockets that exist in the big MDLs seem to me to be running in the face of that rule. Those are claims that we all count as part of MDLs where many times no complaint has been filed with the court. But I want to talk a little bit more about 1938 before we move back to today. One of the problems that the Civil Rules Committee found in 1938, looking at the landscape or prior to that, is the fact that nobody knew what their litigation would look like until they knew who the judge was. They did not know what complaint would suffice. They did not know what discovery would be allowed. They didn't know what motions the court would hear. And oftentimes at the commence of the case, not even the judge would know that, because it was only after commencing the case and talking about it that those decisions would be made. And the rules were designed to solve that problem, to make practice something that you could teach in law schools, read in a book, and follow across the country uniformly so that anybody could know what their lawsuit was like in any federal court. We are in a situation in some of these big MDLs that's a lot like pre-1938. Nobody knows what kind of complaint or not filing a complaint is going to be allowed. Nobody knows what discovery is going to occur or what motions the court will hear until after consolidation and the scheduling conferences or whatever, and the parties negotiate and the judge eventually makes an order that clarifies some of those things. But the result of that is what really is the marker of these large MDLs, and that is the phenomenon of huge numbers of plaintiffs. These are directly related because absent any rule about what the standards are for pleadings and discovery, it of course makes sense for people to do what is known as get a name, file a claim. And therefore, this phenomenon that we're talking about is largely feeding itself, because the absence of rules is the invitation for people to file claims without any sort of investigation as to their merits, the kind of investigation that any lawyer would do in any other type of case pursuant to those rules that I mentioned. So one suggestion to get at this problem is our LCJ proposal for a mandatory disclosure rule in MDL cases that would require plaintiffs to produce evidence of two things early in the case. And those two things are exposure to the alleged cause and an injury that results from that cause. I think that a rule like this that exists before the case is filed, before the case is consolidated, and puts everybody on notice that that is how discovery will begin, would be very helpful to all parties, and including the court, because it would help the court focus on the merits. It would help plaintiffs make sure that the facts of their case are involved. And I would point you to a very interesting new study by Professors Birch and Williams, which surveyed plaintiffs and shows that plaintiffs, one of their biggest complaints about the MDL process is that nobody is looking into the facts of their case and allowing them to share their stories. So it would help plaintiffs with that. It would help defendants know the claims against them, and it would serve judicial efficiency by providing a strong disincentive for people to file claims that have no relationship at all to the case. You know, people who never took the product and never were exposed to it. So that's where I'll begin the discussion, and look forward to all of your comments.
Thank you very much for that, Alex. Very thoughtful. Next then to speak, we have Patrick Luff, who is a senior attorney at Fears Nachawati, the law firm. He's very well published on the subject of mass torts and particularly MDLs. And most interestingly, his cat is called Sammy Davis Jr. And that made me giggle, and I thought I'd share it with you. So, Patrick, over to you.
Thank you. Again, my name is Patrick Luff, and it's a pleasure to be here today. I come at this issue from, I think, somewhat of a different perspective, because prior to my practice career, I was an academic and researching writing on the issue of mass torts. And so I've dipped my toes now in both the academic side of this discussion and the practice side of this discussion. And in fairness to Alex and Ben, I won't spend my limited time simply rebutting the issues that have been raised, because I think we'll have lots of time for that. We have very limited time today, and so what I'd like to do in my time is raise a few issues that I hope will serve as springboards for discussion with the other panelists, and maybe add a few points of rebuttal just by virtue of my spot in the queue. So I want to talk about maybe the good, the bad, and the ugly. And starting with the good, in terms of recent developments, I would suggest that the common narrative that we see is that things like litigation funding are a net negative. And built into that discussion, to me, seems to be the unproven premise that the result of litigation funding is, as I think Alex suggests possibly in some of his comments, that they facilitate the filing of claims that lack merit. Now, I think truly that is an empirical question that we simply need to consider with further study. But if that turns out not to be empirically true, and if it turns out to instead facilitate the filing of meritorious claims, then that completely changes, I think, the narrative in our understanding and our evaluation of litigation funding. Now, having said that, there are a number of nuanced issues in between there. For example, what are the ethical duties that it can raise and the like? And those are some of the issues that, unfortunately, we simply don't have time to address. But I want to caution, at least, that when we think about these things like litigation funding, we don't do so without examining the unstated premises that are packed into the criticisms that we have of these procedures, including criticisms that I myself would share. Now let's talk about the bad. And this is it with, of course, my respect and apologies to Alex, but some of the concerns that I have with the proposals to rework the federal rules of civil procedure, rework the federal rules of evidence, is that while they may be helpful in facilitating a particular sort of litigation or reaching a particular end result in litigation, they fundamentally undermine the Seventh Amendment right to a jury trial, which have equal pride of place with the First Amendment right to free exercise of religion, the Second Amendment right to keep and bear arms, and should be given appropriate and equal respect, both by academics addressing the issue and by courts and others who are involved in fashioning rules of evidence and rules of civil procedure. Now, certainly it's true that we are not living in the same world we lived in 1938. Having said that, it's not as though the MDL process occurs in a vacuum. We have a big fat book called the Manual for Complex Litigation. It's on its 4th edition, which was published in 2004. And while not mandatory, it is certainly a very comprehensive guidebook that is followed very, I won't say closely, but it certainly is used as persuasive evidence and persuasive authority in every litigation that I've been involved in mass torts, including mass torts at the state level. And so to suggest that the courts are acting in an entire vacuum in the MDL process, I think is just counterfactual. More to the point, there's also a federal rule that does encompass how things are going to proceed in consolidated and joint trials. It's Rule 42. Now, the difficulty arises because of the lack of context that is provided. It simply it allows the courts to fashion rules and procedures that facilitate consolidated or joint trials and otherwise further the goals of Rule 1 of the Federal Rules of Civil Procedure. Now, finally, let's talk about the ugly. Because we're talking about recent trends in MDLs, I think it's important to note that defendants in these MDLs, companies, have identified a means of essentially short-circuiting the MDL process entirely. It has been called the Texas two-step in bankruptcy, and it has, I guess, a special resonance for me because I'm coming to you from Dallas, Texas. And that process is as follows. First, a company decides that it's going to get rid of all of its liability for a particular type of tort or injury. All it has to do under the current corporate structure laws and the current bankruptcy laws is to engage in a divisive merger in Texas where it splits off a new entity from the parent company, assigns that new entity all of the liability for a particular injury, then move that entity to North Carolina, file bankruptcy, and then determine what price it's willing to pay to settle the entirety of a tort docket. That is precisely the strategy that has been used by multiple companies involved in asbestos-related litigation, most notably Georgia Pacific, and just last week by Johnson & Johnson, one of the most solvent companies in the United States with one of the highest credit ratings. And so I think we are in a very interesting time right now, and certainly a time where MDLs are likely to have to confront the reality that if the Texas two-step process is a viable one for companies moving forward, what it allows companies to do is to create injuries on a mass scale and then determine what it's going to pay to settle it, to settle a mass tort by fiat. That is in essence what the Texas two-step process allows, and something that I expect will be a topic of serious consideration and discussion in the next several years.
Thank you, Patrick, and certainly food for thought, suggesting that the MDL process isn't even fit for purpose and perhaps needs deep reform on a wider sense. And to round us out of the panelists before we start the discussion is Professor Teddy Rave. Teddy has been an academic dealing in civil procedure and complex litigation for some time, and certainly very thoroughly published on the subject, and no doubt will have an expert view to unfold to us. So Teddy.
Thank you. Thank you, Matthew, for that intro. It's a real pleasure to be here. So since I'm the academic on the panel, I feel like it's sort of my role here to try to put things in context a little bit. So I want to talk first about the growth of MDL and these statistics. As I think was mentioned a little bit earlier, much of the growth here is driven by one case, and that's the 3M earplug MDL. MDLs across the board aren't really growing. The 3M MDL accounts for 2/3 of all MDL cases. That's just one case. If you take that out, most of the growth that we've observed recently goes away. Actually, the number of motions for centralization in MDL has been declining for about a decade. And the rate at which the JPML grants those motions has also been declining. And over the past 5 years or so, the JPML has actually denied slightly more motions than it's granted. I also think we need to be a little bit careful about which numbers we use when we talk about the size of MDL. So in some ways, pending cases can be a deceiving number because large MDLs tend to take, the cases in those litigations tend to take longer to resolve than the average civil case. And so if you're looking at cases in MDLs that are sitting on dockets for longer, that might give you a sense that they're a bigger share of the federal litigation than they are. And I think also we need to be careful about thinking about MDL as the relevant category of cases. So MDL as a whole is not necessarily the right target for reforms or really where the problems that people are talking about are seen. Most MDLs are small. 75% of MDLs have fewer than 100 cases. More than 90% of MDLs have fewer than 1,000 cases. So generalizing about MDLs, I think, can be a little bit misleading. What we're really talking about are big mass tort MDLs. As Alex said, there are only about 16 cases that have more than 1,000 cases. And so I think it would be a mistake to try to make changes across the board to MDL to deal with problems that we observe in just a handful of very large cases. Now, I want to be clear, there's no doubt that MDL is a very big and very important part of the litigation landscape today, and that it has grown over the past several decades. But I don't think we need the MDLs make up 60% of the federal caseload talking point to make that true. These are big, important cases, no matter how we slice it. I also want to talk a little bit about this idea that there are no rules in MDLs, that judges are just making it up, and that we need special rules of civil procedure for MDLs. I think it's important to remember that we already have rules for MDLs. These are called the Federal Rules of Civil Procedure, and they are extraordinarily flexible rules. So Section 1407 doesn't give the MDL judge magic powers, but it does give the MDL judge all the powers of a district judge. And under the Federal Rules of Civil Procedure, federal district judges have a lot of power to manage the cases, their cases in the manner that they deem necessary. So the federal rules were designed in 1938 to be trans-substantive default rules. They were consciously designed to be adaptable to any type of case. And so they built in a lot of discretion for judges to modify them when the needs of the case called for it. So for example, just to get a sense of what kind of discretion we're talking about, Rule 16 empowers the district judge in any case, not just in MDLs, to modify the timing of initial disclosures, modify the extent of discovery, limit the time to join parties or amend pleadings or file motions, to determine the appropriateness and timing of summary adjudication, to take appropriate actions for settling the cases, and to facilitate the just, speedy, and inexpensive disposition of the action. Rule 26A allows the district judge to modify or even eliminate the default rules for initial disclosures. Even lone pine orders, which many plaintiffs and academics complain about, are authorized by Rule 56. So Rule 56F says that the judge can, after notice to the parties and a reasonable time to respond, grant summary judgment sua sponte. That's essentially what a lone pine order is. So this is not, as Judge Katzlich described it, some kind of judicial border country where the rules are few and law rarely makes an appearance. The federal rules of civil procedure apply to MDLs just like they do in all cases, and they give the district judges a tremendous amount of discretion over case management. I think perhaps most importantly, Rule 16 expressly authorizes any district judge in an MDL or in any case to adopt special procedures for managing potentially difficult or protracted actions that may involve complex issues, multiple parties, difficult legal questions, or unusual proof problems. So the idea that we need to codify special rules for MDLs, I think runs counter to the whole thinking of the federal rules of civil procedure. I wonder why we would want to put more constraints on a judge in the most complicated and exceptional cases. And I actually think that the kinds of disclosures in LCJ's proposed amendment to Rule 26A would be useful in a lot of MDLs. But the courts already have the power to do this, the power to require fact sheets making those kinds of disclosures under Rule 16 and 26. They don't need a new rule to do that. And it's probably better suited as an off-the-rack best practice than as a mandatory rule. These sorts of disclosures aren't necessarily going to be appropriate in every MDL. So I don't know why we'd want to tie the MDL judge's hands in the biggest and most complicated cases. You can amend the rule to say, unless otherwise ordered by the court, and make it look like the rest of the federal rules. But then I think we're back where we started. Judges can already do this when they think it's appropriate. There's a trend towards, in all of these discussions, towards what I've started to call MDL exceptionalism. Right? We talk about these cases as if they're special, and academics are guilty of it too, right? So one way that we get people interested in our work is to say that it's exceptional. And many of the cases that make their way into MDLs are big and complicated cases. But I think we often overstate the exceptional nature of MDL. The rules are designed to handle things like that. All right, thank you. I look forward to our discussion.
Well, thank you for that, Teddy. And so the point Teddy makes is that MDL is really no different from any other element of the civil docket. But of course, you know, they do have special characteristics. And is that something that should be regulated specially by the rules? And I suppose the best person to talk about that is Alex. Do you have anything to say in relation to how particularly your procedural suggestions would benefit MDLs in general?
Sure, and Matthew, thank you for that. I think that I might surprise Teddy by telling him that I think we share more common ground than he might suspect on this. Our argument is not that MDLs are special or different or create special rules, but to the contrary, Rule 1 of the federal civil rules that you just quoted also says that those rules apply to every action and proceeding. But what is happening today is that they apply to every action and proceeding except MDLs, which, regardless of how you want to argue the statistics, is a large percentage of the federal civil docket under any measure, and growing in the last couple of decades, as you acknowledged. It's interesting to me that that Teddy has pointed out that the rules of civil procedure give a lot of discretion. And I think that is manifestly true, and everyone understands that. It's interesting because one of the main arguments against bringing MDLs within the rules is that the rules would be too restrictive and would constrain judges and make it inapplicable rules that they would have to navigate. But that isn't what the federal civil rules do. And I often like to ask a rhetorical question of name a current federal civil rule that unduly restricts judges from what they want to do to manage their cases. The fact is that the people who write the rules are geniuses, and they are very focused on this issue of making sure that that they are pragmatic and useful and drafted in a way that gives the court power but not constraints. And that is what would happen if the committee moved forward with a rule that started bringing MDL cases back within the rules. So I think Teddy and I agree that these cases are not their own special category. What defines MDLs, particularly the big ones that we're talking about, is one thing: numerosity of parties. And it turns out, apparently, that the current civil rules are not well in tune with managing cases with numerosity of parties, like we're talking about, thousands or tens of thousands of plaintiffs. And so if the rules are no longer providing that kind of pragmatic guidance for courts and parties, they should be amended. And that's where we get to our suggestion of the disclosure rule. It is not designed to be a replacement for all discovery rules, but in the dynamics of these cases, a simple disclosure of evidence of exposure to the harm and an injury from it would go a long way to remedying the pragmatic problem that the discovery rules currently written would be very hard to manage in a case with tens of thousands of plaintiffs. And in the meantime, it would help plaintiffs get their facts before the court. It would help the court manage the cases and help defendants know what the claims are against them, while also providing the important judicial system function of policing the docket to make sure that there are not, that it's not getting clogged with cases that are meritless and not have any relationship to the underlying claims.
I'm going to start opening this up to questions from the audience. So if any of the attendees want any questions to ask, please put them in the chat to me and I'll make sure they get through the panel. Now I know from my keen sense of these things that Ben has a question for Patrick in relation to what he said. And Ben, if you want to go for it.
You have a really great sense of these things. I have no idea how you knew that. It's telepathy over Zoom, I guess. It actually just picks up with where Alex left off. I was struck by Patrick's comment about how reforms to the rules could potentially undermine the right to a jury trial. Yet it does seem like there's at least reasonable consensus on this panel. I think Teddy acknowledged it, that requiring more robust disclosures for cases that get filed in large personal injury, MDLs would benefit certainly defendants, the judicial system, and as Alex just pointed out, it might enable plaintiffs' attorneys to become more familiar with their cases. In my experience, what we see is that plaintiffs' attorneys usually resist having to do this and are often successful in arguing that it's overly burdensome. So I would just ask of Patrick, who's a plaintiff's attorney, I'm just generally curious, is it a real burden to provide initial disclosures like this? What are the downsides to requiring something like that?
Thanks, Ben. It really is a question that really hits at one of the fundamental issues that I think we all agree are present when we're talking about MDLs and mass torts generally. And that is one of imperfect information. Now, the proposal that I understand to be coming from Alex is an initial exposure, say, for example, evidence of an initial exposure. Now, the real devil there is in the details. Is it an affidavit saying, I, Patrick Luff, took Xeljanz on this date, and is that going to be sufficient evidence? I submit to you that under the rules of evidence in the common law, that's sufficient to get me to a jury if I have the injury claim and the other things that I need to go forward to a jury. But if the evidentiary burden is higher than that, say, for example, I have to show a receipt that I purchased Roundup at Home Depot or something like that. Well, then I submit to you that what is being proposed as a rule of procedure or rule of evidence is contrary to what is required under the 7th Amendment, which is I can have my evidence of exposure and the jury can believe it or not based on the cross-examination that I'm sure to face at a jury trial. But that's an example of the sort of problem that would be raised by this sort of procedure, particularly, again, if it is the sort of procedure that requires more robust disclosures than simply say somebody to meet their burden of going forward as they would face in any one-off case.
Patrick, that sounds all right in theory, but when you're in a case like 3M and there's 250,000 plaintiffs, getting each one in front of a jury and getting cross-examination of each one to test the quality of their evidence, absent some stipulations and such like, it's not as easy as it sounds.
I think that's absolutely right. Now, what that raises to my mind is two problems. Number one, the default premise, again, seems to be that this is a problem about there being too many lawsuits, for example, and not that there's a problem with corporate misconduct that leads to large-scale catastrophic injuries. Now, that is, again, I think, simply an empirical question. If it is the case, for example, that 3M combat arms earplugs were defectively designed, then the problem is not that there are too many cases. The problem is that there's large-scale harm that has to be dealt with in the most efficient way possible. And of course, that leads us, I think, to the very central issue of mass tort litigation for the last 50 years at the very least, which is how do we manage this large-scale litigation that involves common questions of law and fact in the most efficient way?
Matthew?
Yeah, go.
I think that what we're hearing there is the argument in favor of exceptions. If I heard that correctly, the answer to Ben's question is, in an ordinary lawsuit, if you are one plaintiff suing one defendant, you would do your due diligence and you would know the facts and have the evidence ready to go. But if you file 10 of those cases or 100 of those cases, that you should no longer have the responsibility to do the due diligence to figure out whether your plaintiff has a claim before filing it with the court. And I think that is exactly what is the argument for rules not applying, and contrary to the idea that the rules apply to all cases. The fact is that the rules of due diligence should apply the same. And if somebody can't provide, make the very low burden of understanding whether their plaintiff has a claim, has no business filing it. And the ad hoc procedures in some of these big cases are not only inviting it, but they're kind of making it acceptable and maybe even required for people who find a name to file the claim. Why wouldn't you? If you have no idea whether that evidence is ever going to be required in your case, and you don't know anything about what the procedures, what motions, what discovery is going to happen, and there's no burden, of course you're going to file the name, and rather than doing the diligence. But that is not how the rules apply to our, all cases, all matters in our civil justice system. And that's why that in this case, in an effort to bring the practices of MDLs within the fold of the federal rules to treat them like all other cases, there ought to be some mechanism that gives pragmatic guidance to that, acknowledging fully that these cases, because of the numerosity of parties, are going to require some different techniques than they are for one-on-one litigation.
We have a question from the floor from Cheryl Bowie, and that question is, what options are available if more information comes out after an MDL settlement for plaintiffs who didn't necessarily get the best deal in that circumstance? Anybody want to take a punt at that? Ben, you've been suspiciously quiet.
Well, I think it's tricky in any settlement. It's a large scale in an MDL, but I mean, you could have a one-off injury case, a car accident or something like that. And after this, after it settles, new information could come could come out about the extent of the plaintiff's injury or perhaps newly discovered information about the defendant. So the numerosity of MDL proceedings makes it challenging, but as a principle, I'm not sure it'd be handled much differently. It's the same problems as in ordinary litigation. Often these are complicated medical causation cases, which is a challenge, but I think all that stuff just needs to be negotiated in the settlements.
Matthew, I'd like to add to that good observation. I mentioned earlier the Birch-Williams study that surveyed actual plaintiffs in MDLs. One of the conclusions it came to was the following: without the right information going in, how could we expect the right result? And so, it's complicated after a settlement to change the outcome to make sure that it fits the case. But that is the reason why an initial disclosure rule and other early discovery is the key to this, because unless the defendant and the court and the plaintiff's lawyers know the facts of the cases, how do we expect them to come up with settlements that meet the needs of those plaintiffs? What's happening now is that cases are being settled when nobody has ever investigated the facts of those cases, and that is not in keeping with the very most basic tenets of our civil justice system.
So can I jump in, Matthew?
Yeah, Teddy, go.
Yeah, so I think this discussion is an interesting and important one, right? And we have this idea, this field of dreams problem, right? If you build an MDL, if you build it, they will come. Once the MDL is up and running, then cases are gonna flow into it. Though I guess in some sense that maybe is evidence of MDLs being successful at reducing litigation costs, right? If the costs of litigation go down, then we should expect more claims to be filed. And I don't think we can just assume that all of those claims, all of those additional claims are meritless claims. These may be cases that, where it would have been too expensive to litigate them alone, but they have real merit. And so I don't think we can just assume that all of the additional cases are meritless. I'm also not sure why the screening has to happen at the outset. Why it's so important that this is the first thing that happens in an MDL. If weak claims end up sitting on the docket while the parties and the judge focus on common issues that have the potential to resolve the litigation as a whole instead of just some subset of claims, I'm not entirely sure what the harm is in that, right? This is not like a class action where a defendant might be pressured into settling weak claims because they can't stomach even a very small risk of losing a huge amount of money at a trial. There's no all or nothing moment in the MDL where plaintiffs can win the whole thing. They can't win a trial until after remand. So we'll get to the individual issues eventually. And perhaps in some cases it would be helpful to get to them sooner. But that's why I think it's important to give the judge a lot of discretion in when to focus on those issues and which issues to focus on first. If defendants don't want plaintiffs to bring these weak claims, don't pay them in settlement. Don't settle claims without knowing what's in them. Figure it out.
Patrick, you wanted to come in on that?
Sure, and I think Teddy just made my point in conclusion there, which is when you think about, I mean, I do not have the luck to be involved in MDLs where I don't have to show that my clients are injured by a product in order to get paid. But if Alex is aware of some, I would like to know what they are so that I can get involved in them. What happens in MDLs is, in the early phases of the litigation, you will have a meet and confer process about fundamental issues about whether the tort is going to go forward at all, the motions to dismiss and that sort of thing. Concurrent with that, you'll likely have discussions about the short form complaint process, which will allow plaintiffs to file these individual complaints on behalf of the individually affected parties. And then shortly thereafter, concurrent with that, you will have a plaintiff assessment questionnaire, plaintiff fact sheet, a plaintiff profile form. They come by different names, but what they provide is precisely the sort of information that Alex is asking about, which is, did you take the product? When did you take the product? What was your medical treatment? What were your damages? And those are things that always happen right in the meat of the litigation that are followed shortly by a very extensive deficiency process spearheaded by the defendants in the litigation that try to whittle down the docket. And so just to echo what Teddy said, one, I'm not certain that this is a problem at all. Two, I'm not sure that defendants are really paying money on cases that are not meritorious. Certainly, they're not paying money on my unmeritorious cases because I don't bring those cases. And third, when it comes to timing, I think there's real reason to have flexibility in the joints to consider things like dispositive motions before you undertake the inefficient and burdensome process of plaintiff profile forms, assessment of those profile forms, and a deficiency process that really can take up a large body of the litigation.
Matthew, I think that there are two main compelling answers to these questions of why do it by rule and why do it early. Number one is that it is a huge jumpstart to discovery. If you want to understand what those claims are, you need to understand the claims. And let's say a pharmaceutical product might have different disease categories. You can't just look at a list of names on a sheet of paper and say, well, it looks like we have 4 or 5 disease categories, and maybe we should do some discovery on those 5. You only know that if you know what product was taken and what the alleged harm from that was. And so to have discovery start at the beginning of the case instead of months into it. And as Patrick just very well described, what happens in these big cases is that cases are filed, the case is consolidated, months go by, there's a scheduling conference of some sort. Eventually the parties negotiate the sort of first round of disclosures or whatever discovery is going to get, and that's entered several months into the case, and that has several months later, the deadlines for that are several months later. One of the biggest MDL cases, it was 7 months after consolidation that the census order was signed. And that census order had deadlines for compliance that were well out in the future. So number one is if everybody knew, even before the case started or day one of the case, everyone knows that that the discovery is going to start with evidence of exposure and harm from the plaintiffs. You would know so much more about the case so much earlier, and you wouldn't have to negotiate or spend time working it out. Now, very importantly, number two is the prophylactic effect, because when everyone understands on day one that the first thing that's going to happen in the case is that you're going to be required to show evidence of exposure and harm, people will do their due diligence and they will understand their cases before they file. And we won't be 3 years into these big cases and still dealing with tens of thousands of claims that nobody has looked at. And so it's really those two purposes: jump-starting discovery, which will make the cases faster and more efficient because you won't have to deal with these. And number two, you're just going to have fewer claims because there's going to be a little more of the same kind of essential homework that plaintiffs always do before filing individual cases done earlier in the case.
Thank you for that, Alex, and thank you to the panel for what has been a very interesting discussion on a very salient topic for the time being. I'm sorry to those members of the audience who I couldn't get their questions answered, but hopefully we covered it in general terms in any event. So once again, my thanks to Patrick Luff, Ben Halperin, Alex Dahl, Teddy Rave, and the staff here at the Law and Economics Centre. Please check out masonlec.org for any future events, and particularly the Tribal Law 101 event on November the 12th. Thank you all again, and thank you very much for coming.
Thank you, Matthew.